I'm Deborah Martin-Owens. I'm the Executive Director for the Office of Diversity Inclusion here at the New York City Bar Association. And I welcome you this evening. Again, thank you for coming out on this rainy day. It's so great to see you. We were kind of concerned what the attendance would be, but I'm very happy to see everyone in this room. Tonight's program is 400 Years of Perseverance, the Legal Implications of the 1619 African Arrival. And Professor Gloria Browne-Marshall and I, when we were thinking about this program back over the summer, we were thinking of what title can we have. We wanted to talk about perseverance more than pain, perseverance more than what we know in the history books, to really demonstrate that 400 years later, that there's still a resilient group of descendants here in this world, in this country. And so we are really excited about focusing on that lens. So I welcome you here. As you know, I'm sure if you're a City Bar member, or if you're not, you need to talk to me. We're celebrating our 150th anniversary next year. How amazing is that? Give that a clap. 150 years. It starts on February 1st of 2020, so we're so excited. There's going to be quite a few programming and events and opportunities to sort of get engaged, so please look out for your emails, your friends who are City Bar members. Please come out to all of our events. We're going to have it all year long, and we're really excited. I mean, who gets to say that they're 150 years old? So many thanks to Professor Gloria Browne-Marshall, who's a professor of constitutional law at John Jay College. Thank you so much, Professor, for being here tonight. I also want to thank my team. I have people ask me all the time, like, what is your team? It's like so many people. I'm like, no, it's just two. And it's, it's two, I'm a team of two. And it's Christina Overton, who's in the back. Christina, please, thank you for this. Christina designed these. She designed the books, and so we're so excited. And then the second person is Devanshi Shah. Devanshi, I don't know where she is, but Devanshi does everything in terms of whatever I say, hey, let's do this, and she does it. So really want to thank these strong, brilliant women of color who support the work I do here. And now I will introduce Professor Gloria Browne-Marshall. I have this here, but I'm a big believer that I don't like to read bios. We all can read. There's no reason for that, but I know that Professor would like me to say a few things about her. She's a professor of constitutional law at John Jay College and is a founding member of the Gender Studies faculty. She teaches constitutional law, race and politics, gender and justice, and evidence classes for graduates and undergraduates. I always said, evidence still eludes me to this day. It just eludes me. Professor Browne-Marshall litigated cases for the Southern Poverty Law Center, Community Legal Services of Philadelphia, and the NAACP Legal Defense Fund. She was a law clerk in the Eastern District of Pennsylvania, as well as in the courts of Common Pleas in Philadelphia. She has tons of books which are going to be outside for purchase if you have an interest in purchasing one of her books. Again, the rest of her bio is here. The professor has been all over the country, in the world, would I say? Some places talking about this topic. So it's so exciting for her to be here. Recently, she did a sort of overview for the National Bar Association when it was here in New York back in July. And so we're so happy to have her here. And you're probably wondering, why is the City Bar doing this? Why not? Why not, right? The City Bar is a place for all of us as attorneys or future lawyers to come and engage and have a wonderful conversation. And we would be not the City Bar, right, if we didn't talk about this topic in this 400th year. So I think this is an appropriate place, and as lawyers, I'm really excited to be able to delve in sort of the legal aspects of this historical moment. And of course, I was thinking about a good quote. I'm a quote person. If you've seen my newsletters that come out every month, I always have a quote. And so this quote was really resonated with me, and it's something that we always see if we come into the big room, what's called the meeting hall, but we never really look at. And I'm going to read it. The bar, if it is to continue to exist, if it would restore itself to the dignity and honor which it once possessed, must be bold in defense, and if need be, bold in aggression. Samuel J. Tilden, February 1st, 1870. Exactly, right in the front. We see this all the time, and we never. Now think about it. He's saying this, he's the 25th governor of New York, and he's saying this in 1870. So even in 1870, they were grappling with things that we still are today. So without further ado, Professor Gloria Browne-Marshall.
Thank you so much.
You're welcome.
Thank you, Deborah, and thank all of you. Thank you for coming out. I truly appreciate it. It's New York City. You could be anywhere, doing anything, and you chose to be here, and that means a lot. It means a lot not just to me as an attorney, as a civil rights attorney at that, but it also means a lot in history's sake, in the eye of history. And that's what I want you to think about, because that's what we're talking about. But it's not just history. When Deborah asked me to do this, I was excited because it's not just a matter of legal history, it's a matter of the present, and something that I call vestiges. And many of you, if you studied civil rights or studied constitutional law from the standpoint of racial justice, then you know vestiges are the remnants of things from the past. And we are dealing today, in the 21st century, this year, going forward, with the remnants of things left over from slavery, the remnants of things left over from Jim Crow segregation. And we in New York think we're protected from those things, but we're not, because New York played a major role in the industry of cotton trade and many of the other commodities that came from the South through our stock market here. I like to say we're almost like trust fund babies, that there was an investment made on the backs of others for which we have gained a benefit, we being those people alive today. So even though those may say, I'm an immigrant, what do I have to do with anything? Well, this country would not have been so attractive, perhaps, but for the benefits that were accrued over time that were gained on the backs of others. Now, I said that, and even though it's raining outside and the traffic is terrible, the sky didn't fall. The earth didn't rumble. No one I can see so far has imploded. We can have these conversations. This country is no longer in adolescence. It's no longer a gawky teenager. This country is full grown. And it's time for us to pay attention to some things that have been left behind in our haste to grow. Some people have said that law is a powerful tool. I would add law is a powerful tool for good as well as for oppression. And for most of this country's history, it's been used as a very powerful tool to undermine the competition when it got too close. Now, one thing that I do in my classes, what I say, and I'll say to you, and some of you in this room have taught as well, that we can disagree on the interpretation, but we should not have a disagreement on the fact of its existence. So the fact of its existence is something that we need to understand, because in dealing with diversity and inclusion, we need to understand what does it mean to be diverse, and then what does it mean to be included. And for this country, primarily, we've looked at inclusion from the standpoint of those who are excluded. So for me, in my interpretation of our history and racial injustice, that racial injustice was created to justify the greed that came with slavery. Now, I'm going to ask this question. If you have people, partners and firms and other co-workers in the room, just don't raise your hand or anything, but look at it this way. If your boss, manager, employer could work you for free, would they? Now remember, don't raise your hand, you might be in trouble tomorrow. For those people who are retired, would you have been worked for free if you, under the laws of the time, could have been worked for free? When you think about those people who are actually doing many of the things in your office, and you are the person who has to pay the bills at the end of the day, if you could get all those for free at the same high quality, would you? Could you? And if the law said that you could, and if they said no, they could be harmed, That's what slavery is. That's what slavery was. The ability to get things for free and then force the person to do it for free and then have the law on your side if they rebelled. So then what does that have to do with 1619? Deborah and I were very intrigued with the title for this program. And so when I thought of the legal implications, I said, that might be something that triggers some thought. The legal implications of 1619. What does that mean? Well, first let's go to the document that we actually have copies of this for some people who might be interested. So I said that the question of whether or not there is an existence of the document, existence of the law, should not be in dispute. But the interpretation, of course, even we know this with our justices of the Supreme Court, there can be disagreements among all of us. But I want you to know about this document. In 2006, back when Barack Obama was just a funny name for someone few people knew outside of Illinois, and The Apprentice was a show that had been on a couple of years by this guy named Donald Trump. Back in 2006, I was a member of the American Bar Association's Individual Rights and Responsibilities Committee. And during that time period, I championed a resolution that was passed by the American Bar Association. And it states, and I quote, "Resolved that the American Bar Association urges the United States Congress to create and appropriate funds for a commission to study and make findings relating to the present-day social, political, and economic consequences of both slavery and the denial thereafter of equal justice under law for persons of African descent living in the United States, and authorize the commission to propose public policies or governmental actions, if any, that may be appropriate to address such consequences." That was our American Bar Association. That resolution passed on February 13th, 2006. Before any of this talk of reparations that we have currently, we had this resolution among lawyers. We can do things like this. And we can not only pass resolutions, we can also make change based on those resolutions. So I'm hoping by the end of my talk with you that some of you will take a copy of not only the resolution, but the report that comes with the resolution, and that you will have action take place within this body and within other legal bodies. And we will make change, because that's what lawyers can do. Law can be a tool for good as well as a tool for oppression. So as we begin our 1619 journey, let's start on a good note. Relatively good note. And I talk about one of my favorite dead persons, and that is Queen Nzinga. How many of you are familiar with Queen Nzinga? We have 2.5 people. Queen Nzinga was a warrior queen of what is now Angola. It was called Ndongo then, Ndongo Matamba. If you can imagine the landmass of the Congo, then you can think of what she inherited as queen. As a little girl, she watched her father, the Ngola, the leader, actually negotiate with these different leaders, negotiate with the Portuguese, because the Portuguese came over to the area known as Angola in the 1500s from Brazil. If you look on the map, Brazil is right across the Atlantic, and then you have Angola, straight line across. We have the Portuguese then start off as one leader of a nation with another leader of a nation. And Queen Nzinga, the reason why I find her so fascinating is because she rose up after her brother would not take the leadership of the region that he should when the Portuguese began to invade that region. First, they wanted precious metals. Not finding these precious metals, they found another precious cargo, the labor they needed to expand the Portuguese empire into the New World. All the monarchs were doing it. Let's expand into the New World. That expansion with the Portuguese, the French, the Spanish, and then later on, at the tail end, we have the English. The Dutch were also a part of this. So now the Portuguese are going into this area now known as Angola and deciding that they're not just going to take precious metals, they're going to take a precious cargo of human beings for that labor force needed for Brazil and these other areas. And Queen Nzinga actually negotiates a peace treaty. In 1622, Queen Nzinga is negotiating a peace treaty with the Portuguese. She's not only a monarch, as you find with the English monarchs, sitting on the throne, or the stool, as they called it in Africa. She also knew how to use a spear and a sword. I told you, we start off with a happy note. She fought hard against the Portuguese, lived to be 80 years old, fighting the entire time. At the end of the day, though, Queen Nzinga was defeated in many ways because I'm here today and so many other people. The first of those Africans arriving in 1619, the 20 and odd Negroes, as documented in John Rolfe's diary, John Rolfe, the secretary of the Virginia colony, those 20 and odd Negroes were from Angola. They were on a ship. They had been kidnapped from their homes. They had been taken to Luanda, the port, and then from there, they were kidnapped again on the high seas, and then in search of an English port, they find the Virginia colony. The Virginia colony was founded in 1607 by King James, and that's why it's called Jamestown. King James, the same King James of the Bible, King James version of the Bible, that same King James, finally getting into the expansion of England into the New World. In 1619, July 30th of that same year, the same year the Africans arrived, that's the year the House of Burgesses began. The legal legislative body for that colony, the House of Burgesses. Here we have this confluence. Where is this landmass? Virginia. This is the land of the Powhatan Native Americans. So here we have the influx of the English, the Irish, the Scottish, the European. We have an influx of the Africans on the land of the Native Americans. We have our diversity. Diversity did not begin with affirmative action. Diversity did not begin with the Birmingham sit-ins or any of those actions that led to integration. Diversity was here in 1619, when all of those cultures came upon Virginia colony. We also have the lawyers. The lawyers are in the room in 1619. The Africans arrive. Now, what is the legal status of these Africans? We know about the indentured servants, correct? People are familiar with indentured servants. Indentured servants were the poor whites. They were the poor Europeans. They were the ones whose lives were very dismal in England and other places, and they traded their freedom for a certain number of years under contract to work for free. And they would work for free, and once their indentured contract ended, they would be free to have land and live their lives in the colony. Now, this is a risk because it's dangerous to cross the Atlantic. How many of you have actually been to Jamestown? Okay, if you have a chance, it's a small place. If you go to the fort, it's a swamp. It was a swamp then, it's a swamp now. Only they have like state and government money, so they have souvenirs in the gift shop. But back then, when you look at the size of this fort and see how small it was, that hundreds of people are jammed into this fort. The Native Americans, of course, grew weary of these people who decided they were visiting from the Native American standpoint. And the Native Americans had a very intricate, civilized governmental system already in place before the Europeans arrived. The Africans had, as I said, a system of government that was in place before the Portuguese started taking the Africans by force into Europe and other places around North and South America. So it wasn't as though we had civilization because the Europeans were there. They had a different system of governing, and their system of governing was one that those people in government could be there if they owned land and if they were of high character. And usually they were the landed class with money and an education of some kind of that time. So here we have those three cultures all in one place. How does the law work in this? What are the legal implications? Are those 20 and odd Africans, men, women, and children, who arrive in the colony in August of 1619, are they indentured servants? Are they enslaved? Are they free? Because based on that will be what? Their treatment under law. We still do that. Different people are treated differently under law. Certain immigrants are treated a certain way based on their immigration status under law. So here we have this question, and from here we go forward. If they are indentured servants, then they can work under a certain length of contract and be free to engage in economic commerce. They could engage in the political system. They could engage in marriage. They could engage in all of these things as any other person who arrived from Europe. If they're not, then they're servants. And that servant class could be the indentured servitude. But at that time, and I've had a couple of debates with scholars, one very well-known scholar who always refers to his 2 PhDs from Cambridge. But at the same time, I said, you're 2 PhDs from Cambridge, but I don't see a law degree in there. Because if there is no law, then it's not legal. It could be a tradition. It could be culture. It could be assumed, but it's not law. So were these people enslaved under law? My argument is that they were not. And the other reason why I say they were not is because I'm going to show you how little by little chattel slavery was put in place by the House of Burgesses. Now, we know about the House of Burgesses. It was just in the news as Virginia went blue, and you hear about all of that. Virginia has such a long history. And I try to study that history. I go to Virginia at least once a year because I have no true social life. And I am intrigued. I am greatly intrigued by all of this. And I've been studying it for, probably about 10 to 15, maybe even 20 years. And so I think it's fascinating for us to see Virginia as the cornerstone of America, because it is. And even though there were colonies that predate Virginia, the St. Augustine colony of Spain in what is now Florida predates it, but we don't all speak Spanish. We speak English because this was an English colony, and that's why Virginia is so important. So as we go forward, I want us to think about Marian Anthony Johnson. And Marian Anthony Johnson will be the best example I can give you. What the history and what the legal records show of the Africans, the 20 and odd and others who arrived, there is an actual census record for Angela. Angela is a single woman. She's thought of to have been a girl, maybe in her mid-teens when she first arrived. And she went on to work for the Pierce family as a servant. That was her legal status, a servant. You also had Isabella and Antonio, but they have no last names. Their son, the first child born in the colony, is William Tucker. He has a name. The name he is given is the name of Captain Tucker, the last name of Captain Tucker. And even though Isabella and Antonio have no last names, they're considered servants. But we don't know if they're ever released from their indenturement. But Marian and Anthony Johnson have names, first and last names, and I'm telling you, I was just gonna say, in case you're guessing, no, their names were not Marian Anthony Johnson when they were in Angola. They were not living next to the Smiths and the Kennedys. Their names had been anglicized by the English, and prior to that, they had been made Portuguese names before they left. And I had a chance when I went to Angola to see the church. Each enslaved person was bathed, baptized, and then given a Portuguese name before being placed on the ship. And some have been said from records there that they were giving something to drink, and it was probably something in the beginning to calm their nerves so they would not rebel. So they're giant vats filled with liquid that given to those people leaving Angola for that long, weeks-long journey. Here we have this question then, Marian Anthony Johnson. Let's see what happened, looking at voting rights and looking at criminal justice. Voting rights and criminal justice. So those landed people actually got to be the lawmakers. They were landed and they discovered something very early, and that was tobacco. They figured out a crop that would grow. Tobacco is very labor intensive. And so those indentured European servants, Once they finalized their indenturement of 7 to 12 to 13 years, got to go free. Their contract ended, but they also took with them the knowledge of growing tobacco. They then became competition for the landed class. The Africans now bring into this colony, and we know about Africans and labor. People talk about enslavement and labor. Enslavement and labor, yes, there's a lot of that, but they also had skills. They knew about how to grow crops. They knew about how to tend animals. They also had metalworks. They had creative skills. They brought with them skills necessary for this colony to grow. When I talk about this being a trust fund situation, when you think about it, that colony, if they did not have those other types of abilities, of talents, the colony would not have grown. That's how reliant they had to be on those Africans. So if there is work as an indentured servant for free, there is a problem when people don't want to work anymore. They're treated poorly. John Punch is an African. John Punch runs away. He runs away with James Gregory, a Scotsman, and also with a Dutchman named Victor. The three men run away, and in 1640, they're caught, and the House of Burgesses must adjudicate their fate. Criminal justice. What happens? They decide the punishment would be an additional years onto the indenturement of Mr. Gregory. Additional years for Victor. However, John Punch in 1640 not only has his indenturement extended, but it's extended for life. So this is the first time we begin to see the difference under criminal justice between the Africans and the Europeans. We also see, and this is, as we look at this, the reason why it's so important, I want you to think about the similarities in our present day society. Think about those similarities in the disparity in criminal justice. The disparity in sentencing laws began in the 1600s. 1654, we have Elizabeth Key. Elizabeth Key, her mother is Black Bess, so you have an idea she's African. Her father is not, and so he is European. Her father goes back to England. He says to a friend, "Take care of my daughter. She's a mulatto." And I always like to say, and we need to get this out of the way, as long as there have been different ethnicities and different races in the same place and sundown, there have been mixed race people. Okay, as long as when the sun goes down, 9 months later, mixed race babies. So this is not new either. This is not new. So here we have now Elizabeth Key. Elizabeth Key's person who's supposed to take care of her, the caretaker, decides he's going to enslave her for life instead. He then attempts to do this. She sues. This is the first lawsuit brought by a woman of color in America in 1654. This is how long there's been the pushback of trying to use the law for good. This battle back and forth between oppression and freedom has been going on for hundreds of years. It did not begin with the Civil Rights Movement. So Elizabeth Key brings this case, and initially she loses, but then she goes forward. The legislative body decides to allow her to go free as a free woman. Her father acknowledged her. Her father actually reprimanded his son in public, and this is in the transcript, the law transcript of the case, that he said, "This is your sister." And they used this as evidence to show that she is the daughter of an Englishman. But what did the House of Burgesses do after that? They changed the law. And this then becomes the system that we're working under for 400 years. Once there's a push forward for freedom, there's a push back in the change of the law. They changed the law and said, one, no person who is a child of an Englishman or any European and an African can inherit from that European father. Think about how slavery would have ended a long time ago if there was a right of inheritance that continued. You don't even think about it. All of those babies born to these European men, they stopped the right of inheritance in the 1600s. Then the next question was that of status. What is going to be the status of these babies born of a European man. They said the status under law would be that of the mother. So these babies are born enslaved. Now the other question becomes, what ways can they get out of this bondage? Christianity was one. If they were baptized, being baptized, but then under law, the law based on English law, no Christian could be enslaved. So what did they do? Of course, many Africans said, I see the light, hallelujah, thank you, Jesus. But then what happened? The laws changed again. And they said, under law, that there can be no freedom from slavery based on Christianity. Why? They could not be baptized because it was thought that Native Americans and Africans had no souls. And if one has no soul, it does not matter if you go through the baptismal procedure. The effect is not to have a soul saved if a person has no soul. Next we have and that was in 1667. By 1669, we have a law, and this one I really need for you to hear, and it's referred to as the casual killing of a slave. Because by this time, and it's always been this way, we must assume, because laws are based on perceived behaviors or behaviors that society wants to see happen. So if you want to stop something, you have a law to prevent something. If you see something happening, you have a law to say we're going to support certain things. When you have a law that says in 1619, the Virginia legislature enacted the following statute titled, An Act About the Casual Killing of Slaves. The law declared that, quote, if any slave resist his master and by the extremity of the correction should chance to die, that death shall not be accompanied by felony, end quote. So as early as 1669, Black lives didn't matter. And you begin to see what we're dealing with today when I talk about the vestiges of our criminal justice system, that this has been in place from the beginning. The core of our country is based in this. By 1676, we have Bacon's Rebellion. Who's familiar with Bacon's Rebellion? Okay, we have 4.5 hands. Bacon's Rebellion is very important, and more people should, okay, calm down. Bacon's Rebellion is very important in American history because it is the first mass rebellion of the people, the regular people against the elite. But it's also important in American racial justice history because it's a rebellion of white indentured servants, free Africans, and African slaves coming together. And it so frightened the elite when they put down this rebellion that, and I conjecture here, and many people have as well, that this is the time in which it was decided that the racial component was going to be used to delineate between poor whites and people of African descent and other people of color. That it was frightening to have these two groups come together. It was too powerful. How can we keep them at odds? And one way to keep them at odds is to use something like the pigment of the skin, their nationalities, something that's indelible. And so that's when you see this turn where the differences, like the John Punch case, would be that people of European descent would get a little bit more. Their sentence would not be as long. And then the law started to change that if a European ran away with an indentured servant who was African, and they were both caught, the European indentured servant would take on the same punishment as the African. And you begin to see, why would a European then come in league with the African? Why would they join together, even though they had common issues of concern? But the laws were put in place that would keep a division between those two groups. By 1680, this Virginia law was put in place. And this one, I think, is very important. It speaks to, once again, what we're dealing with today. And this is the law of 1680 that takes away the right of self-defense, and I quote, "Whereas the frequent meetings of considerable numbers of Negro slaves under the pretense of feasts and burials is judged of dangerous consequences, it is enacted that no Negro or slave may carry arms such as any club, staff, gun, sword, or other weapon, nor go from his owner's plantation without a certificate, and then only on necessary occasions. The punishment, 20 lashes on the bare back, well laid on. And further, if any Negro lift his hand against any Christian, he shall receive 30 lashes. And if he absent himself or lie out from his master's service and resist lawful apprehension, he may be killed. And this law shall be published every 6 months," end quote. With this, the right of self-defense has been taken away. Slavery is the law. Self-defense, protecting one's children, wife, parents, is a crime punishable by death, punishable by death. What we need to understand is, if we think about our cases today, think about the time in which we would actually step forward and say, no, I'm not going to, have someone hurt my child. And to say here, if they lift a hand, and Christian is considered any European, then that is a crime punishable by death. And what we have and continue to have is this balance between the necessary labor that these Africans are providing, not just the Virginia colony, these are Virginia laws, but colonies along the East Coast, all the way up to New York. And we see by these laws that are put in place to stop self-defense that people are rising up. They are rebelling. They are running away. They are saying no. And that's why I'm saying what you read between the lines of these laws is that people are fighting for their freedom. And so the laws are enacted to stop that fight for freedom, to undermine that humanity. But also, and I always like to say this and make sure it's understood, there have always been Europeans who stood up for what was right. Always. I wish there had been more, but they'd always been there. And I give you this example. In 1688 in Pennsylvania, Pennsylvania passes the first anti-slavery law. So we must take this back to our conversations. When we say, oh no, everyone was doing it. No, everyone wasn't doing it. No, they weren't. There were people speaking up in the 1600s and speaking up in the 1600s in Virginia. Because once again, reading between the lines in the law, what I interpret, if it takes this amount of time for people who are landowners, who are in a situation of the perfect storm, they are lawmakers and landholders who need this African labor and Indian labor, Native American labor. They need it, they want it, and they have the tool of law to make it theirs. And yet it's not done in one fell swoop. There are people within the House of Burgesses who, and I am assuming, must be resisting this, or else everything would have been passed at once. Now let's go back to Marian and Anthony Johnson. You might ask what happened to them. Marian and Anthony Johnson, this African couple, they have land of their own in the 1600s. Marian and Anthony Johnson have land of their own and servants of their own in the 1600s. These Africans, Marian and Anthony Johnson, who have come over from a slave ship in the hold of a ship through the Middle Passage that takes weeks, if you can imagine that. They came up on the shores of Jamestown. They were servants at first, in the beginning, because they came in the early stages of the 1620s. So they had a choice. They then worked hard, fulfilled their indenturement, and had their freedom in order to have land of their own, servants of their own, and to top this off, they had European and African servants of their own in the 1600s. But you don't hear about Marian and Anthony Johnson, the same way you don't hear about Queen Nzinga, because this country does something else. It not only has acts of commission, it has acts of omission. And if you omit what other people have done, when you omit African history, of kings and queens. Queen Nzinga was not the only warrior queen. There were many warrior queens in African history. If you omit these things, then you see people of color, in particular people of African descent, as these poor folks. Some of you might, oh, they need help, poor people. They have no history. I wouldn't be one. I happen to be a very proud African American, and I was very proud before I knew about Queen Nzinga. But one thing that makes me prouder is the fact of the resistance that took place all of this time. The constant resistance, not just of tradition and not just of society, but of law. Marian Anthony Johnson, think about this. Think about what kind of country we would have right now if they were allowed to persist on their road. Where would we be now? But the law came in. The House of Burgesses decided that they are aliens, and therefore aliens could not hold land. They changed the law, giving them alien status, forcing them out of the colony and confiscating their land. We don't know Marian Anthony Johnson exists, except for the fact that people like me with no social life and others go into the archives, the Rockefeller archives in Virginia, and look at the legal records. And Marian Anthony Johnson had a fire. Their farm caught a flame. We think it might have been the hater neighbor, but we don't know. But we do know there was a fire. And they asked for a tax abatement in the 1600s. For those tax attorneys out there, yes, in the 1600s, tax abatements were taking place back then. They asked and were granted this tax abatement, but they had to list all that they owned. And that's why we know they existed, and that's why we know they had these things. They were forced out of the colony, and then their descendants are then found in Maryland. But think about the difference. Think about how close Anthony Johnson came from being able to participate in the legislative body because he was a landholder. And maybe this is what caused this change in the law, was that the fact that he could have been a full citizen within the colony, have full rights within the colony, because he had the power then to go into the House of Burgesses. When I worked on this book, The Voting Rights War, and I looked at the ways in which we have used the criminal justice system to undermine voting rights. And to me, having Marian Anthony Johnson then made into aliens is one, because the thought of being an alien meant that there was something that they were doing that was counter to the nature of the colony, the safety of the colony. But we also have another way to look at this. There were people, and we should say once again, who once again fought, I should say, again and again fought against these laws that were put in place or rose up despite these laws. In 1768, for example, the first black politician is Wentworth Cheswell. Wentworth Cheswell, he was a constable in Newmarket, New Hampshire. We don't know about Wentworth Cheswell. We don't know that people were fighting to rise up despite all of this. And this is what's so important. It's not just the laws that oppress. And as Deborah pointed out, the sad times, the bad times, the hard times, they were always there. What I like and what makes me so proud is the fact that people pushed against that despite the consequences of the time. We need to know that by the time we get to 1705, chattel slavery is in place. Pretty much across the East Coast, chattel slavery, but definitely in the South, which meant chattel is movable property. So that's what Africans were, movable property. It's already been established they have no right of self-defense. That meant that women could not fight to preserve their virginity, their sanctity, their bodies. That meant that parents could not protect their children. And chattel slavery meant that children could be sold away from their parents on the auction block. That is American history. That is our history. But let us also talk about the people who are fighting against it and the way law worked on both sides, because that's so important. We have in 1787, of course, the drafting of the U.S. Constitution. Those founding fathers, some of whom are slaveholders, many of them are slaveholders, but some of them are not. And the reason why the word slave is not in the Constitution is because those who are not slaveholders refused to sign it if the word slave was in there. We know the Constitution is a compromise agreement, but here's something else that was happening in 1787 in Massachusetts. And this is Prince Hall, because the issue of education has always been a primary issue. And Prince Hall is a Mason. I don't know if you have Masons in your family. My husband was a Mason, my uncle and my grandfather was a Mason. Yes, so we have the Masons. And so once again, things were segregated, so you have the black Masons and the white Masons. And so Prince Hall is the first black Mason. So you can go back if you don't say anything else. One is Prince Hall is the first black Mason. You know the Africans arrived in 1619. You know the House of Burgess began in 1619. But did you know that the Mayflower landed in 1620? We were here before the Mayflower. To understand these concepts, to put them in historical context, will be to better understand how long the fight was going on for education. And here's what Prince Hall says in the document that he uses as a petition to argue for the education of free African children in Massachusetts. In 1787, the same year the Constitution was drafted, and he writes, "As by woeful experience we now feel the want of a common education, we, therefore, must fear for our rising offspring to see them in ignorance in a land of gospel light, and for not other reason can be given, this they are black. We therefore pray your honors that you would, in your wisdom, some provision would be made for the free education of our dear children." End quote. These were the types of petitions being made to the government, being made to the lawmakers by advocates, activists, because that's what Prince Hall was. He was an activist in the 1780s. The fight for full inclusion in our society has been going on for a very long time, and I'm going to skip through very quickly to tell you two more very important examples. Another is Mum Bet. Elizabeth Freeman is her name. Elizabeth Freeman, named Mum Bet, brought a lawsuit in the 1780s based on the Massachusetts Constitution. Back then, the majority of people were illiterate, so they had now announcements in the town square. They would stand in the town square and read off the legal documents because people couldn't read. So the town crier would read off these legal documents. Well, she was going shopping one day, and she was enslaved. Her mistress was horrible and kept beating her, and she had this horrible scar on her arm where she was hit with a piece of hot metal. And she hears the Constitution speak of freedom. And you know what Elizabeth Bet does? Elizabeth Freeman, Mum Bet? She walks to a lawyer's office on her way from the store. She walks to the lawyer's office, and she says, "Can I sue for my freedom under the Constitution?" And he takes her case. Yes, in the 1780s, Mum Bet's case is successful. She gains her freedom under the Massachusetts Constitution. But once again, because you don't know about Elizabeth Freedom, and that's Elizabeth Freeman, and what she changed her name to Elizabeth Freedom, she changed it because she said if she had to live a day as a free person, and that was the last day she would ever have, she would live it as a free person, as a freeman, for one day, then to stay a slave. But we don't know about Elizabeth Freeman. We don't know about her law case and so many other law cases that were brought by people over the years. We know about Dred Scott, and we know in 1856 that Dred and Harriet Scott brought a case for their freedom that went to the Supreme Court, and the Supreme Court, Justice Taney, ruled as part of this court's decision that a black man had no rights, a white man need respect. That's the Dred Scott ruling of 1856. And then we have a civil war that people don't talk about at all either. We know more about the wars of Europe than we know about our own Civil War. But by 1816, it's because of the Africans who were in the Civil War fighting on behalf of the Union that the war was won by the North. If you have a chance, next time you're in Washington, D.C., go to the African Civil War Museum. There's an African Civil War Museum, and it's in Washington, D.C. proper. You can go to it and you can see it. You can look at the names. The names are there of those Africans. My relative happens to be one of those Africans who fought in the Civil War. But then we say, well, President Lincoln freed the slaves, and that's very interesting. He did, technically. But we like to also say that the enslaved freed themselves, because once you put a gun in a man's hand and said you can shoot your enemies, you can shoot the white ones, but only the ones in the gray uniforms. Are they really going to go back to working for somebody for free for life? They turned the tide of the war. But what happens in 1865 with the 13th Amendment? It abolishes slavery except as punishment for a crime. The 13th Amendment abolishes slavery. Read the language one time. The 13th Amendment abolishes slavery except as punishment for a crime, which triggers the criminal justice system to use black codes or criminal laws that are focused on African American behavior. So certain places a person can't loiter. Remember the loitering law, though, from 1680 that said Africans, based on pretense of feast, cannot loiter, cannot join together? That's how long this has been going on. Oh, black boys loitering on the corner. We need to understand that the black codes that were put in place from the convict lease system, triggered by the 13th Amendment's provision, that if they were in the criminal justice system, their labor could be used for free. And if their labor could be used for free, that's the labor that rebuilt the South. And so these people were then arrested and used for anywhere from 3 to 5 years, sometimes 10. Just keep in mind, last year they found a burial ground in Texas with the remains of at least 48 people that are thought to have been worked to death or died in circumstances in one of these places where they were being used as incarcerated labor. That was last year. The convict lease system lasted until World War II. So when we go forward with the 14th Amendment, people don't know, many of you probably do, that the first provision of the 14th Amendment gives citizenship at birth. That is where we get our citizenship at birth. It's the first provision of the 14th Amendment. And the reason why they gained citizenship at birth, it was for the Africans to get that back from the fact that the Dred Scott decision said that they had no right of citizenship. So if you want to thank all Africans for your right of citizenship at birth, please put the check in the mail. We have privileges and immunities. The Equal Protection Clause, as you know, most of you, I'm sure, know, the Equal Protection Clause of the 14th Amendment was put in place because of the Dred Scott decision. It was put in place to give equal protection to Africans who had had that taken away with that 1857 decision of Dred Scott. And then, of course, the 15th Amendment gives black men the right to vote. Next year is the 150th anniversary of the 15th Amendment, the passage of the 15th Amendment. I hope this body will do something, because it's also, of course, the 100th anniversary of the 19th Amendment that gave women the right to vote. All of that is next year. So the 15th Amendment gives black men the right to vote. And we have in 1870, the first black US senator in 1870. We have the first blacks in Congress, black US representatives. We have over 4,000 black men in positions of power, political power. We have blacks in state government. We have black lieutenant governors. All of these people. But do you know anything about them? Because of this rule of omission, you probably don't. But at the same time, in 1871, the federal government passes the Anti-Ku Klux Klan Act. Why? Because you have the rise of oppression at the same time. You have the civil rights cases, and you've all read those in the 1870s, in which they took away these individual private actions, the right to actually rise up and say that these private actors who are taking away the right to have full access to the theater, to restaurants and other places, that there was nothing the federal government could do. Little by little, by the time we get to 1896 with Plessy versus Ferguson, we have open season on people of African descent. In a voting context, let me put it this way. Prior to the 1896 Plessy decision, there were, in Louisiana alone, over 130,000 registered Black voters. In Louisiana alone, over 130,000 in 1896. By 1900, there are less than 5,000. That is the effect of Plessy versus Ferguson on the Black voter. So as we see this nexus between the African American experience from the 1600s up to this time period, and so many of you are familiar with what happened from the 1900s and the fight up to this period, the legal fight, I think it's so important for you to understand that it didn't start with the civil rights movement of the 1950s. It didn't start right after Plessy versus Ferguson in 1909 when the NAACP was founded, even though it played a major role in that battle. That this has been ingrained in our culture from the 1600s. The use of the law to undermine the progress of people of African descent has been a part of the American experience. And the fight against that abuse of law has also been a part of the American experience. And the protest in between is continuous. I'm going to end with this. And this is a quote from Frederick Douglass. Power concedes nothing without demand. It never has, and it never will. I stand for questions.